Welcome back to SCOTUS Oral Arguments and Opinions. In this episode, we'll discuss the June 18th, 2025 Supreme Court opinion in the case called EPA versus Calumet Shreveport Refining, L.L.C., case number 23-1229. We'll first walk through the majority opinion and the dissent, then discuss implications. Finally, we'll read the tea leaves and trace Justice Gorsuch's dissent to oral arguments. Please note that this summary is read by an automated voice. The question presented in this case is whether venue for the refinery's challenges lies exclusively in the D.C. Circuit because the agency's denial actions are nationally applicable, or, alternatively, are based on a determination of nationwide scope or effect. 42 U.S.C. 7607B1. Justice Thomas delivered the opinion of the court in which Justices Alito, Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson joined. Justice Gorsuch filed a dissenting opinion in which Chief Justice Roberts joined. This case centers on a seemingly mundane but critically important question. Which federal court should hear challenges to EPA decisions? The Clean Air Act requires most refineries to blend renewable fuels like ethanol into gasoline, but small refineries can petition for hardship exemptions if compliance would cause them disproportionate economic harm. In 2022, EPA denied 105 such exemption requests from small refineries across the country, issuing these denials in 2 large batch notices. EPA claimed these challenges could only be heard in the D.C. Circuit Court of Appeals, but the refineries wanted to sue in their local regional courts instead. The dispute boiled down to interpreting the Clean Air Act's venue rules, which create a 3-part system for determining where EPA cases should be heard. Nationally applicable EPA actions must go to the D.C. Circuit, while locally or regionally applicable actions normally go to regional courts. However, there's a crucial exception. Even local actions must go to the D.C. Circuit if they're based on a determination of nationwide scope or effect. The Fifth Circuit Court of Appeals sided with the refineries, ruling that EPA's denials were purely local decisions that should be heard regionally, not in Washington, D.C. The Supreme Court disagreed with the Fifth Circuit in a 7-2 decision written by Justice Thomas. The court held that while EPA's individual denials were indeed locally applicable actions, they fell within the nationwide scope exception because they were primarily driven by 2 nationwide determinations: EPA's interpretation of what constitutes disproportionate economic hardship, and its economic theory that refineries can pass renewable fuel costs on to consumers. The court emphasized that EPA used these nationwide principles to reach a presumptive decision to deny all petitions, then only looked at individual refinery circumstances to confirm this predetermined outcome. The court vacated the Fifth Circuit's decision and sent the case to the D.C. Circuit, where all the refinery challenges will now be consolidated. Justice Gorsuch, joined by Chief Justice Roberts, dissented, arguing that the majority created an unnecessarily complex test that will make venue disputes more difficult and expensive to resolve. The dissenters preferred a simpler approach. Look to what the Clean Air Act's substantive provisions actually require EPA to determine, which in this case was only whether each individual refinery faced hardship, not any nationwide determination. All right, let's get to Justice Thomas' majority opinion.
The Clean Air Act, CAA, establishes a comprehensive venue framework for judicial review of Environmental Protection Agency, EPA, actions designed to ensure proper distribution of cases among federal courts. Under 42 U.S.C. Section 7607B1, nationally applicable EPA actions must be challenged exclusively in the D.C. Circuit, while locally or regionally applicable actions ordinarily belong in regional circuits. However, locally or regionally applicable actions that are based on a determination of nationwide scope or effect must be reviewed in the D.C. Circuit if EPA finds and publishes that such basis exists. This tripartite system reflects congressional intent to channel nationally significant EPA actions to the D.C. Circuit while keeping most regionally focused matters in local circuits. Under the CAA's Renewable Fuel Program, most domestic refineries must blend specified amounts of ethanol and other renewable fuels into transportation fuels they produce. The Act provides a phased exemption scheme for small refineries, those processing no more than 75,000 barrels of crude oil daily, allowing them to petition EPA for exemptions based on disproportionate economic hardship. Following this court's decision in Holly Frontier Cheyenne Refining L.L.C versus Renewable Fuels ASN, which clarified that small refineries could obtain exemption extensions even after their original exemptions had lapsed. The D.C. Circuit remanded pending exemption cases to EPA for reconsideration. EPA then proposed and ultimately denied 105 small refinery exemption petitions in two omnibus notices issued in April and July 2022. EPA's denials were based on two principal determinations. First, its interpretation that disproportionate economic hardship covers only hardship directly caused by renewable fuel program compliance. And second, its economic theory that renewable identification number, RIN, costs are fully passed through to consumers, creating a presumption against granting exemptions. EPA applied these determinations uniformly while conducting confirmatory reviews of individual refinery circumstances. EPA asserted in its denial notices that the denials were reviewable only in the D.C. Circuit, either as nationally applicable actions or alternatively as locally applicable actions based on a determination of nationwide scope or effect. Small refineries challenged these denials in multiple regional circuits. Most circuits either dismissed the challenges for improper venue or transferred them to the D.C. Circuit. However, the Fifth Circuit retained jurisdiction, rejecting EPA's venue arguments and ruling for the refineries on the merits. The Fifth Circuit reasoned that EPA's actions were merely locally applicable because their legal effect was limited to the petitioning refineries, and that the actions were not based on determinations of nationwide scope or effect, because EPA still examined refinery-specific facts before issuing denials. Held, EPA's denials of small refinery exemption petitions are locally or regionally applicable actions that fall within the nationwide scope or effect exception, requiring venue in the D.C. Circuit. Section 7607B1 creates a two-step inquiry for determining venue. First, courts assess whether an EPA action is nationally applicable or only locally or regionally applicable. If nationally applicable, the case belongs in the D.C. Circuit. If locally or regionally applicable, courts proceed to the second step to determine whether the nationwide scope or effect exception applies to override the default rule of regional circuit review. 1. To identify the relevant action, courts must look to the authorizing CAA provision rather than how EPA packages its decisions. The enumerated actions in Section 7607B1 make clear that this provision treats each activity the Clean Air Act allows the EPA to take as a distinct action. Kentucky versus EPA 123F, 4th 447, 460. Because the CAA allows a small refinery to petition EPA for an extension of its exemption and requires EPA to act on any petition submitted, each EPA denial of a refinery's exemption petition constitutes its own action for venue purposes. 2. An action is nationally applicable if it applies on its face throughout the entire country, or only locally or regionally applicable if it applies only to particular localities or regions. Sierra Club vs. EPA, 926F, 3rd, 844, 849. EPA's denial of a single refinery's exemption petition applies only to that refinery, a particular entity in a particular place, making such denials paradigmatically locally or regionally applicable actions. 3. EPA's argument that it can control the unit of action for venue purposes by aggregating similar petitions into omnibus notices lacks any statutory limiting principle and would effectively give EPA veto power over venue. EPA's position that any action affecting more than one circuit is nationally applicable would render actions with plainly local or regional focus nationally applicable simply because the locality or region straddles circuit lines. B. Because EPA's actions are locally or regionally applicable, the court must determine whether the nationwide scope or effect exception applies. This exception requires that 1. The action is based on a determination of nationwide scope or effect, and 2. EPA finds and publishes that such action is based on such a determination. All agree the second requirement is satisfied. 1. A determination refers to EPA's justifications in taking the action. Determinations are of nationwide scope if they apply throughout the country as a legal matter, de jure, and of nationwide effect if they so apply as a practical matter, de facto. Kentucky 123 F 4th at 465. An EPA action is based on a determination of nationwide scope or effect only if that determination lies at the core of the agency action and forms the primary explanation for and driver of EPA's action. Texas versus EPA 829 F, 3rd 405, 419. This requires more than but-for causation. It requires that a justification of nationwide breadth be the most important part of EPA's reasoning. Courts should evaluate this de novo. Applying this framework, EPA's exemption denials were based on determinations of nationwide scope or effect. EPA's interpretation of disproportionate economic hardship under Section 7545099B I and its RIN pass-through theory are clear determinations of nationwide scope or effect that apply generically to all refineries, regardless of geographic location. These determinations form the core basis for EPA's denials because EPA used them to reach a presumptive resolution to deny all petitions, then considered refinery-specific factors only to confirm it had no reason to depart from this presumptive disposition. Where EPA relies on determinations of nationwide scope or effect to reach a presumptive resolution, those determinations qualify as the primary driver of its decision. EPA's confirmatory review of refinery-specific facts is merely peripheral by comparison. Texas 829 F 3rd at 419. The court rejects EPA's argument that determination covers only the resolution of unsettled issues, as well as respondents' argument that determination is a term of art applicable only when a CAA provision textually directs EPA to make a determination for the entire nation. The court also rejects the argument that EPA's consideration of refinery-specific facts precludes the exception's application, noting that the exception requires an action be based on, not based solely on, a determination of nationwide scope or effect. Vacated and remanded.
Justice Gorsuch's dissenting opinion. Though I would reach a different judgment, the court and I travel much of the way together. This case involves 6 small refineries. Each petitioned the Environmental Protection Agency for a hardship exemption from the Clean Air Act's renewable fuel mandates. The agency denied all 6 refineries' petitions. The question we face does not concern the merits of what EPA did, only where the small refineries' lawsuit challenging the agency's actions should be heard. The Act instructs that litigation over nationally applicable EPA actions belongs in the D.C. Circuit, while disputes over locally or regionally applicable agency actions generally belong in a regional circuit. 42 U.S.C. Section 7607B1. In parts 1 and 2 of its opinion, the court concludes that these rules presumptively route the dispute before us to a regional circuit, because EPA's decision to deny an individual refinery's petition for a hardship exemption is a locally or regionally applicable action. With all that, I agree. But then, in Part 3 of its opinion, the court pivots. Even when a case challenges only a locally or regionally applicable action, the court observes, the Act routes it to the D.C. Circuit if EPA's action is based on a determination of nationwide scope or effect. Applying a new multi-step test, it announces, the court concludes that EPA's actions at issue here were based on such a determination. As a result, the court holds, the right venue for this case turns out to be the D.C. Circuit after all. In my view, that pivot is a mistake. The Clean Air Act's venue provision works in harmony with its substantive provisions. Throughout, those substantive provisions direct EPA to make certain determinations before it may take certain actions. When it comes to acting on a small refinery's hardship petition, Nothing in the Act's substantive provisions calls on EPA to make a determination of nationwide scope or effect. Instead, the Act requires the agency to evaluate only whether a particular small refinery seeking an exemption would suffer a hardship without one. Accordingly, the Act's venue provision routes this dispute to a regional circuit, just as the Fifth Circuit recognized below. The Court's new and reticulated test for assessing venue disputes under the Act strikes me as both mistaken and likely to render simple venue questions unnecessarily difficult and expensive to resolve. I start with how I would analyze this case. The Clean Air Act's venue provision, found in 42 U.S.C. Section 7607B1 supplies three basic rules. First, challenges to nationally applicable agency actions must be brought in the D.C. Circuit. Second, challenges to locally or regionally applicable agency actions must be filed in the appropriate regional circuit. Third, as an exception to the second rule, challenges to locally or regionally applicable agency actions belong in the D.C. Circuit if they are based on a determination of nationwide scope or effect. The central question this case poses concerns the relationship between the second and third rules. When is a locally or regionally applicable action under the Clean Air Act based on a determination of nationwide scope or effect? As I see it, the Act itself supplies the answer. Working in concert with the Act's venue provision, the Act's substantive provisions tell us what kinds of actions the agency is lawfully authorized to take, and when those actions may be based on determinations of nationwide scope or effect. Here, the relevant substantive provisions permit EPA to take a specific action, namely, the granting or denying of a small refinery's hardship petition. But by their terms, those provisions do not call for a nationwide determination when the agency acts. Instead, the only decisions EPA must make are refinery-specific ones. Accordingly, the dispute before us belongs in an appropriate regional circuit. To appreciate how the Act's substantive and venue provisions interact, begin with a look at the substantive provisions addressing the renewable fuel standards that lie at the heart of this case. As a rule, Section 754502 requires the nation's fuel supply to include ethanol or other renewable fuels in fixed amounts that increase over time. But the Act also permits EPA to take various actions inconsistent with that general rule if it makes certain determinations. So, for example, Section 754507 AI allows EPA to waive some renewable fuel mandates based on a certain determinations. For its part, Section 7410 uses determination or one of its cognates more than 20 times. So, for example, Section 7410B permits EPA to extend the period for the submission of any SIP for up to 18 months, wherever the EPA administrator determines necessary. And Section 7410G allows EPA to disapprove a governor's decision to suspend a SIP component if the agency determines that his decision does not meet certain statutory criteria, including whether the suspension is necessary to prevent substantial increases in unemployment. Now consider where the Act's venue provision sends disputes about EPA actions under these substantive provisions. Suppose EPA determines that it is necessary to extend the submission deadline for SIPs across the country, and the agency acts accordingly pursuant to Section 7410B. In those circumstances, an argument might be made that Section 7607B1 routes disputes about that action to the D.C. Circuit. But if EPA acts pursuant to Section 7410G to countermand a governor's decision to suspend a SIP component based on a determination that his decision defies the Act's terms, Section 7607B1 would likely send any dispute over that action to a regional circuit. B. With that much in hand, return to the question whether the Act's venue provision directs this lawsuit to a regional circuit or the D.C. Circuit. As we have seen, Section 7545 lays out the Act's substantive renewable fuel standards and generally requires refineries to mix a certain and regularly increasing amount of renewable fuels into the transportation fuel they produce. But Section 7545 also allows EPA to exempt small refineries from these mandates for the reason of disproportionate economic hardship. Seeking to take advantage of this provision, the 6 small refineries before us individually petitioned EPA for hardship exemptions. In the end, the agency denied each refinery's request. Now, the small refineries seek to challenge EPA's actions in court. That challenge belongs in a regional circuit because nothing in the Act's relevant substantive provisions calls for EPA to act on a determination of nationwide scope or effect. Just walk through the substantive provisions addressing small refineries one by one. To account for the fact that small refineries may have more difficulty meeting evolving renewable fuel mandates than their larger rivals, Congress in 2005 granted them a blanket exemption until 2011. After that, Congress directed EPA to extend a small refineries exemption for a period of not less than 2 additional years if the Secretary of Energy determines that the refinery in question would be subject to a disproportionate economic hardship if required to comply with the Act's renewable fuel mandates. Even beyond that, Congress permitted a small refinery to petition at any time for an extension of its exemption for the reason of disproportionate economic hardship. When it comes to deciding whether to grant or deny such a petition, the Act directs EPA to consult with the Secretary of Energy, consider his determination whether a particular small refinery would suffer disproportionate economic hardship if required to comply, and consider other economic factors. Nowhere does the Act call for a determination of nationwide scope or effect. To the contrary, after the blanket exemption for small refineries expired in 2011, all agency actions and determinations became refinery-specific ones. Any doubt on that score is resolved by comparing these substantive provisions with others we have encountered. Section 754507A, remember, allows EPA to waive certain renewable fuel standards based on a determination that implementation of the requirement would severely harm the economy or environment of the United States, or based on a determination that there is an inadequate domestic fuel supply. As that provision illustrates, when it wished to do so, Congress knew how to say that EPA may take a certain action based on a determination of nationwide scope or effect. That we have nothing like that here is a telling sign that the small refinery provisions work differently and do not task EPA with taking any nationally applicable action or making any determination of nationwide scope or effect. EPA's own statements convey the same message. The agency represents that it considers each petition on the merits and examines individual refinery information when passing on individual hardship petitions. EPA represents, too, that it determined that none of the petitioning small refineries merited a hardship exemption only after completing a thorough evaluation of the data and information provided by each small refinery. To be sure, EPA also highlights 2 features of its administrative proceedings that, it says, prove the agency took a nationally applicable action, or at least made a determination of nationwide scope or effect. For one, EPA emphasizes that it bundled the petitions from the 6 small refineries before us, together with a host of other similar petitions, and dispatched them all in a pair of administrative decisions. For another, the agency stresses that, in evaluating each refinery's petition, it relied on a single interpretation of the statutory phrase, disproportionate economic hardship, and a single economic model, the agency's RIN pass-through theory. The court correctly holds that none of this transforms EPA's challenged actions into nationally applicable actions. Yes, the agency may choose to bundle petitions together for administrative convenience, and yes, the agency may apply similar reasoning when faced with similar petitions. But, as the court recognizes, the only action the Act's substantive provisions call on EPA to take is to grant or deny an individual hardship petition, and that is a locally applicable action, not a national one. As I see it, this same insight defeats EPA's suggestion that its actions were based on a determination of nationwide scope or effect. As a matter of administrative convenience, the agency may choose to address a number of petitions collectively rather than separately, and the agency, of course, may, and to avoid acting arbitrarily and capriciously, generally must, apply consistent reasoning to like petitions. But the Act's venue provision does not root cases to one circuit or another based on how EPA packages them or the quality or nature of its reasoning. Instead, the Act's venue provision asks whether the agency based its action on a determination of nationwide scope or effect. And as the Act's substantive provisions make clear, EPA does no such thing when it passes on an individual small refinery's hardship petition. Turn now to how the court resolves this case. As we have seen, the court first holds that EPA's decision whether to grant or deny an individual small refinery's hardship petition is a locally or regionally applicable action. Accordingly, the court starts with the correct presumption that the suit before us belongs in a regional circuit. But then, the court reverses course. While EPA's challenged actions are local or regional ones, the court concludes this case belongs in the D.C. Circuit because the agency's actions were based on a determination of nationwide scope or effect. That portion of the court's opinion strikes me as both mistaken and likely to cause confusion about where Clean Air Act disputes should be heard. To understand why, consider how the court proceeds. Pursuing what it calls an ordinary meaning approach, the court observes that the word determination often refers to the settling and ending of a controversy. Extrapolating from that dictionary definition, the court reasons that any EPA conclusion within the four corners of an action qualifies as a determination. But the court continues whether an action is based on a conclusion of nationwide scope or effect depends on a degree of causality, nor will just any degree of causality do. Proving that some nationwide conclusion, or now the court adds, justification or reasoning, is the but-for cause of the agency's action will not suffice. Instead, EPA must establish that some nationwide conclusion, or justification or reasoning, qualifies as the gravamen, or core, or driver of its action. And when EPA's actions rely in significant part on high, intensely factual considerations, or when the key driver of EPA's action is otherwise debatable, that standard will not be satisfied. Applying all those ideas to this case, the court holds that all of EPA's challenged actions were based on a determination of nationwide scope or effect. That is so, the court says, because EPA's actions, its decisions to deny the small refineries' petitions, rested at their core on a common or nationwide understanding of the statutory phrase disproportionate economic hardship, and a common or nationwide economic model. To be sure, the court acknowledges the agency also undertook a review of refinery-specific facts, but on the court's account, those refinery-specific facts mattered less to the outcomes here than EPA's statutory interpretation and its economic model. I find that chain of reasoning unpersuasive for a few reasons. For one thing, it seems to me pretty far afield from the statutory text. As we have seen, the Clean Air Act's venue provision speaks of actions and determinations, and the Act's substantive provisions do too. And when a substantive provision calls for either a nationally applicable action or a determination of nationwide scope or effect, it says so. To decide where a case belongs, then, no special judicially devised test is required. Instead, lawyers and judges need only open the statute books, find the relevant substantive provision, and follow its lead. As we have seen, the court takes just this approach when addressing the meaning of the term action in the Act's venue provision. There, it concludes EPA took no nationally applicable action because the Act's substantive provisions peg an action to a decision to grant or deny an individual hardship petition. On my view, we should employ that same statute-driven approach to the meaning of a determination of nationwide scope or effect. For another thing, the court's test conflates a determination with the reasons that inform it. Statutes often distinguish between considerations that inform a determination and the determination itself. The Clean Air Act is no different. It authorizes EPA to take certain actions, like waiving renewable fuel mandates or disapproving a single governor's suspension of a SIP component. The Act authorizes those actions if certain determinations are made, like a determination that enforcing the renewable fuel mandates would severely harm the national economy, or a determination that a governor's partial SIP suspension doesn't satisfy certain criteria. And to support its determinations, the agency may offer any number of reasons. To avoid accusations of arbitrary and capricious decision-making, too, the agency will usually employ consistent reasoning in like cases. But none of that means we should conflate the determinations EPA must make under the Act with the reasons the agency offers to support them. For another thing still, I worry that the court's test will prove tough for lower courts and lawyers to apply in practice. Having conflated a determination with the agency's underlying reasoning, the court must find some way to go about sorting and weighing all the reasons EPA may advance. But just consider what its approach entails. First, lawyers and judges must consult the full scope of the agency's reasoning. In this case, reasoning that runs over 280 pages. Next, lawyers and judges must parse out which aspects of that reasoning are particular to a locality or region, and which are national in scope or effect. Finally, lawyers and judges must weigh those two sets of reasons against each other and decide which set was the true driver of the agency's decision, and which was more peripheral to it. Litigation over whether the case is in the right court is essentially a waste of time and resources. When it comes to the simple preliminary question where a case should be filed, the rules of the road should be clear and easy to apply. The test the court announces today can claim neither of those virtues. For the lawyers and judges tasked with applying it, I can only wish them luck. At the end of the day, venue rules are like traffic laws. They simply tell litigants where to go, and they should be easy to follow. As I read it, the Clean Air Act provides a clear rule for cases like this one. Applying that rule here, I would direct the parties to the appropriate regional circuit. The court doing otherwise, I respectfully dissent.
Those were the majority and dissenting opinions. Let's talk about case implications. This decision establishes a framework that could influence how venue disputes are resolved across environmental law, though its practical impact will depend largely on how lower courts apply the majority's multi-factor test for determining when local agency actions are based on nationwide determinations. The court's emphasis on whether nationwide considerations serve as the primary driver of an agency's decision, rather than merely contributing factors, creates a standard that may prove challenging to apply consistently. EPA and other agencies may need to be more strategic about how they structure and explain their decision-making processes, particularly when bundling similar local determinations or relying on broad policy interpretations that could be characterized as having nationwide scope. The sharp disagreement between the majority and dissent suggests this area of law remains unsettled, with Justice Gorsuch's concerns about creating unnecessarily difficult and expensive venue litigation potentially proving prescient. While the decision provides some clarity about the Clean Air Act's venue provisions, it also introduces what the dissent characterized as a reticulated test that requires courts to parse through potentially hundreds of pages of agency reasoning to determine which factors were most important to the final decision. The ultimate significance of this ruling may depend on whether it encourages more strategic forum shopping by litigants and whether the practical difficulties Justice Gorsuch identified lead to inconsistent applications by different circuit courts, potentially requiring future Supreme Court intervention to resolve conflicts. Now let's read the tea leaves from oral argument to decision. Let me start with Justice Thomas, who ended up in the majority but seemed genuinely puzzled during oral arguments about how far EPA could push this bundling theory. Justice Thomas asked Stewart a deceptively simple question. Are there any limits to aggregating different claims and thereby determining venue in D.C.? When Stewart gave a somewhat evasive answer about judicial scrutiny, Justice Thomas pressed harder. What would be a limiting principle if you could just simply aggregate decisions about refineries? Justice Thomas was clearly worried about giving EPA too much power to control where cases get heard. Stewart tried to reassure Justice Thomas that EPA had good reasons for publishing them together, because EPA had issued proposed denials based on a proposal to change its methodology. But Justice Thomas wasn't satisfied, asking whether EPA's discretion was really discretionary rather than having real limits. This exchange shows Justice Thomas wrestling with the exact issue that would become central to the majority opinion: how to prevent EPA from gaming the venue system while still recognizing when EPA makes genuinely nationwide determinations. Justice Gorsuch absolutely grilled the government's attorney, Malcolm Stewart, with a relentless series of questions that telegraphed exactly where Justice Gorsuch was headed. And Justice Gorsuch's dissenting opinion reads like an extended version of those oral argument concerns: Gorsuch's relentless questioning. Justice Gorsuch immediately zeroed in on what would become the heart of the dissenting opinion, that this represents a complete sea change in how these things have been reviewed in the past. Justice Gorsuch pointed out that, historically, they've taken these one by one, and SIPs and hardship determinations have been dealt with at the regional circuit level. When Stewart tried to argue that EPA's new methodology justified the change, Justice Gorsuch shot back with skepticism. So it came up with this pass-through theory? That's the new development? Justice Gorsuch then delivered what might be the most telling line of the entire oral argument. Statutory interpretation. By gosh, I should hope EPA applies a consistent statutory interpretation across the country. And when it comes to economic theories, same goes. Otherwise, it would be arbitrary and capricious. So how can it be that that's what we should look at? This question cuts right to the heart of Justice Gorsuch's eventual dissent. Justice Gorsuch was essentially arguing that if we expect agencies to be consistent, which we do, then consistency alone can't be the trigger for sending cases to D.C. Otherwise, as Justice Gorsuch put it in the dissent, EPA would have carte blanche to root cases wherever EPA wanted just by applying consistent reasoning. The core determination debate. The most heated exchange came when Justice Gorsuch pressed Stewart on what exactly constitutes the determination that matters for venue. Justice Gorsuch noted that the statute requires EPA to determine whether there's a disproportionate economic harm to this particular refinery, and asked, "When I'm looking for a determination, why wouldn't I look to the statute where it uses the very word?" Stewart tried to argue that EPA makes different subsidiary determinations, but Justice Gorsuch wasn't buying it. Justice Gorsuch fired back. How far back does somebody have to go in the chain of reasoning behind the determination that there's no undue hardship to determine where to bring their suit? Justice Gorsuch was clearly frustrated with what Justice Gorsuch saw as the government asking parties to look beyond the actual statutory determination to the analysis behind that and figure out what's the core behind a determination and an action. This exchange perfectly previews Justice Gorsuch's dissenting opinion, where Justice Gorsuch wrote that the court's test conflates a determination with the reasons that inform it. Justice Gorsuch's dissent argues that statutes often distinguish between considerations that inform a determination and the determination itself. The practicality problem. Justice Gorsuch also hammered away at the practical difficulties of the government's approach, asking, how is that consistent with this court's repeated admonitions that venue is supposed to be easy to determine at the outset of the case? This concern became a major theme in Justice Gorsuch's dissent, where Justice Gorsuch wrote that venue rules should be clear and easy to apply, and worried that the majority's test would prove tough for lower courts and lawyers to apply in practice. During oral arguments, Justice Gorsuch painted a picture of the complexity the government's approach would create. Lawyers would have to parse through agency reasoning, figure out what's core, and determine the relative importance of different factors. Justice Gorsuch's dissent elaborates on this concern, noting that under the majority's approach, lawyers and judges must consult the full scope of the agency's reasoning, in this case, reasoning that runs over 280 pages, and then weigh those two sets of reasons against each other and decide which set was the true driver of the agency's decision. How the majority responded. The majority opinion, written by Justice Thomas, directly addresses many of the concerns Justice Thomas raised during oral arguments while rejecting Justice Gorsuch's approach. On the limiting principle issue, Justice Thomas's majority opinion acknowledges that EPA's position that it can control the unit of action used to determine venue lacks any statutory limiting principle and would effectively give EPA a veto power over venue under the CAA. But the majority finds a different solution than Justice Gorsuch proposed. Instead of looking solely to what the statute requires EPA to determine, Justice Thomas's opinion creates the core test that Justice Gorsuch criticized. The majority holds that an action is based on a nationwide determination only if that determination lies at the core of the agency action, and forms the primary explanation for and driver of EPA's action. The ultimate divide. What emerges from comparing the oral arguments to the final opinions is a fundamental disagreement about how to read statutes. Justice Gorsuch's approach, both in oral argument and in the dissent, is essentially, look at what the Clean Air Act's substantive provisions actually require EPA to determine, and that tells you whether there's a nationwide determination. As Justice Gorsuch put it in the dissent, lawyers and judges need only open the statute books, find the relevant substantive provision, and follow its lead. The majority, led by Justice Thomas, takes a more functional approach, looking at what EPA actually did and whether nationwide considerations drove the decision, regardless of what the statute technically requires. The majority opinion acknowledges this is a more complex test but argues it's necessary to prevent the exception from swallowing the rule. This split reflects a broader tension in administrative law about how much deference to give agencies and how to balance simplicity with accuracy in legal tests. Justice Gorsuch's questions during oral arguments showed Justice Gorsuch was deeply concerned about creating a system that would be both unpredictable and manipulable by agencies. The majority, while sharing some of those concerns, ultimately decided that a more nuanced approach was necessary to achieve Congress's goal of routing truly nationwide disputes to the D.C. Circuit. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Up next, Oklahoma vs. EPA. Talk to you soon.